Striking evidence and authentication, keeping improper evidence out in motions for summary judgment and trials against debt collectors. Brought to you by yourlegallegup.com, your advantage if you're being sued by debt collectors. How can I strike the debt collector's affidavit that it used in its motion for summary judgment? A caller on a recent teleconference asked. We get that question a lot, and in today's video we're going to take a quick look at the way evidence works. Striking evidence sounds so tough, almost like some sort of magic really. You say something and voila! Part of the debt collector's case goes away and troubles you no more. Unfortunately, that isn't really the way it works. You can sometimes strike pleadings, but you move to dismiss claims and you object to evidence and try to exclude it. That is, they try to put something in this case a bogus affidavit. The affidavit was signed by the debt collector's clerk who claimed that the original creditor's statements and bills were correct and accurate. We've talked about this before many times. On a motion for summary judgment, you don't want those records in against you. Your whole case will often depend on your keeping them out. So what do? There are two problems to attack. You look at two rules. First, you look at the rule for summary judgments in your jurisdiction. Summary judgments are brought according to a rule, and you need to know that rule if the other side brings one against you. What must the affidavit say in order to get evidence into the record? The rules say that. In most jurisdictions, it will say that someone who knows what the evidence is supposed to be from actual knowledge and experience must swear to its legitimacy. And crucially, the affidavit must affirmatively show the basis for that knowledge. That is, the affidavit has got to tell the court and you how the person testifying supposedly knows what they're testifying about. This is called authentication. Let's look at a simple example of the way that works. Suppose you got a phone call from a debt collector after writing a cease communications letter. How would you prove it? Well, you would need to testify you got the call, right? But you'd need to prove that the call was really made by the debt collector. And since you aren't inside the debt collector's head and they won't testify that they did, you've got to do that in some other way than that sort of direct testimony. To do it, you might testify, for example, that you had received many calls from the same phone number at the same time, all identifying themselves as that certain debt collector. You might testify that you recognized the voice, that they were collecting on the same debt, and certainly that the debt collector identified himself by name, if so. In other words, all that sort of proof that the person who was calling you was that debt collector. That's what you got to prove, because you got to prove that they're the ones who made the call. Notice that these are all things, as I said above, that you actually know based on your very own experience. You want the court to conclude, as you do, that this was a call by the debt collector that you told to stop. All this preliminary stuff that's based on your knowledge is called authentication. In the case of an affidavit about records, the authentication consists of where the records came from and how the person testifying got them, how they kept them, how they came to be in court, all that sort of stuff, again, about the legitimacy of the records. And again, all this must be done from personal and direct knowledge. Look closely at all of the evidence the debt collector tries to put in a motion for summary judgment or trial. If it isn't properly authenticated, you must object to it and move to exclude it. The next attack on the evidence is under the business records exception. We already know that the records of the debt collector should not be admitted on an affidavit by a debt collector. But how do you show it? Again, you look at the rules. This time your state's rules of evidence. We're talking about hearsay and the business records exception. I'm not going to go into these rules here because I've done so many times in other videos. But again, the crucial steps are to get the rule and look at it very closely. Then check every part of it against what the debt collector says. When it is a debt collector testifying to how the records were generated, when, by whom, under what instructions and circumstances, and how they were kept. It should be obvious that this information does not come close to satisfying the direct knowledge requirement for authentication. You're going to want to show that to the court, demonstrate it by making those specific attacks as to authentication. And then one last thing, quite often the records custodian of the debt collector will testify as to facts, the facts that supposedly the records indicate. This is not the function of the business records exception. The business records exception exists to authenticate the documents themselves, and that the records is what comes into evidence when the rule is satisfied, which is almost never in debt collection cases. So suppose the debt collector has two statements with your name on them and a balance. Do these records of themselves show that you owe any money? Does any valid record indicate that you didn't pay it? Does any record indicate that the entries were legitimate? Look very, very closely at the evidence itself. If it does not, you are not attempting to exclude the evidence. You're simply pointing out that it does not prove what the debt collector claims it does prove. It might even be irrelevant, but your primary point here is that it leaves some part of the debt collector's case unproven. So you aren't actually attacking the evidence so much as the case in that situation. So in summary, when the debt collector tries to use business records, you don't try to strike the evidence. You object and try to exclude it. And language counts, by the way. You want to make sure that you call your motions what they really are. You look at the rules for motions for summary judgment, and you look at the rules for authentication of evidence. Then you look at the rule against hearsay and the business records exception to that rule. Every single element of the rules must be complied with before the evidence is admissible. If not, you object and move to exclude it. If it is admissible, you look at it very carefully and attack its relevance and whether it proves what the debt collector says it proves. Usually it doesn't. If it doesn't, you're attacking the debt collector's case. You will do all these things about every piece of evidence. Debt collectors rarely have what they need to win. There's nothing magic about all this. Be systematic and thorough. Do the work. Protect what's yours and don't let the debt collectors rip you off. YourLegalLegUp.com